afternoon, and welcome to the City Club of Cleveland, a citadel of free speech for nearly 75 years. I'm Robert Lustig, president of the club. Today, the City Club Forum presents the Honorable Sandra Day O'Connor, Associate Justice of the Supreme Court of the United States. A magna cum laude graduate of Stanford, she also received her law degree from that university's law school, where she was both on the board of editors of the Law Review and a member of the Order of the Coif, a legal honorary society. Following law school, she became a deputy county attorney in California, and then a civilian attorney for the quartermaster in Frankfurt, Germany. Private practice of law in Arizona followed, and then a period as an assistant attorney general in that state. In 1969, she was appointed to the Arizona State Senate, and she was reelected twice. In 1975, she was elected as a county judge. In 1979, she was appointed to the Arizona Court of Appeals by Governor Bruce Babbitt. After only 2 years on the Court of Appeals, she was nominated by President Reagan to be an Associate Justice of the Supreme Court of the United States. She took her oath of office on September 25, 1981, and of course still remains on that court. Having replaced Potter Stewart, originally she was the Justice for the Sixth Circuit. To you lawyers in the audience, that means something. But since the elevation of Justice Rehnquist, she is now the Justice for the Ninth Circuit. The great Oliver Wendell Holmes Jr. was a disappointment to President Theodore Roosevelt, as he never upheld some of Teddy Roosevelt's ideas. Those who followed our speaker's opinions and have observed her votes again realize that Supreme Court justices are independent, thinking people with minds of their own. The City Club Forum presents the Honorable Sandra Day O'Connor, who will address us on the workings of the United States Supreme Court. Justice O'Connor.
Thank you, Mr. Lustig, and members of the City Club. It's a pleasure for John and me to visit this historic institution of your City Club. You've been hosting these luncheons for a good while. You don't look old enough to me to have been doing this for 75 years. President John Adams once said, "My gift of Chief Justice John Marshall to the people of the United States was the proudest act of my life." Another less satisfied president once referred to one of his appointments to the Supreme Court as my biggest mistake. President Abraham Lincoln nominated someone by the name of Samuel Miller to the court. Before that nomination was made, some supporters of Miller went to see President Lincoln to urge the nomination. They talked for a while, but it was clear that the president had other things on his mind, the Civil War, perhaps. Finally, he turned back to his visitors and said, "Oh, you mean you want me to appoint this man to the Supreme Court? That's important. I thought you wanted me to make him a general." Presidents worry a lot about the quality of their appointments to the court. One reason is that justices are free to ignore the views of the president who appoints them. Another is that justices usually remain in office for many years after the president who appointed them has departed. Under our system, the president makes the proposal and escorts the new justice down the aisle. But the marriage is between the justice and the court. The marriage lasts, if the justice so chooses, for better or for worse, for richer or for poorer, until death do they part. From 1790 until today, there have been only 103 people who have served as justices of the Supreme Court of the United States. On the average, a new justice is appointed every 22 months. Every president, except Presidents Harrison, Taylor, and Carter, has nominated at least one Supreme Court justice. Because of the role of the Supreme Court in our government, there's naturally intense interest in the selection of justices. As I suspect has been the case with most justices, my nomination to the court was not only a great surprise to the nation, but it was an even greater surprise to the nominee. I never aspired to be on the court. I had not thought about it as a possibility. It was clear to me that I was to spend the rest of my professional life as a judge, and I had served happily as a trial judge and was serving on the Arizona Court of Appeals, for whose members I had deep affection and great professional respect. I anticipated that I would spend the balance of my life in our adobe house on the desert, where my husband John and I had many friends, a very pleasant way of life, and where we expected our children to settle. My situation changed dramatically on June 25, 1981, when Attorney General William French Smith called my home and said he wanted to talk to me about the Potter Stewart vacancy. I could not have been more surprised. In the ensuing days, I met with the Attorney General and his staff members, and then with the President and with some of his aides. Then the story broke in the news that I was a likely nominee. I didn't know who disclosed it or why, and I don't to this day. The press appeared en masse at my home and my office. We received so many telephone calls at the house that we couldn't sleep and we couldn't even contact anyone. We had to change our telephone number. On July 6th, 12 days after Attorney General Smith first called me, the President called me at my office and asked me if he could announce that he intended to nominate me to the court. I said that I would be honored if he did. A few minutes later, John arrived, and I told him of the President's call. And we just stood there with our arms around each other, wondering what the rest of our lives would be like. In September, I faced my Senate confirmation hearings. I sat, as some of you may remember, at the witness chair for about 2.5 days on national television, answering endless questions about the Constitution, various cases, and my personal feelings on some of life's great issues. It was an experience I was happy to put behind me. The thought that gave me comfort when few others did was that I knew that Nancy Thurman was giving a tea for me at 4 p.m. on the third day of the hearings. And I hoped that Senator Thurman, the chairman of the Judiciary Committee, would be sure he got me to his wife's tea on time. He did. I was sworn in, as Mr. Lustig noted, on Friday, September 25th, 1981. At the President's request, John and I rode with him and with Mrs. Reagan from the White House to the Supreme Court. I sat in the chair John Marshall once sat in as I awaited the taking of my oath. The Chief Justice administered the oath of office to me, and then I was seated at the end of the bench. I looked down at my parents and at my husband and at my children from that position. And of course, I will never, never forget that moment. The media blitz was overwhelming my first year or so. Everywhere I went, the press was there in droves, taking pictures, asking questions, many of which were inappropriate to answer. And that can get pretty old pretty quick. But funny things sometimes happen as a result of my media exposure, and John sees some of the incidents that I don't see and then tells me about them. For instance, recently in Washington, we went to a restaurant for dinner with one of my law clerks. And on our way out, John heard someone say about me, "It doesn't look like her, but it is her." Some people have asked me if I knew how much I looked like Sandra O'Connor. And a few people, when they hear that Justice O'Connor is present, have walked over to shake John's hand and tell him how proud they are to meet a justice. Now, an unanticipated sideline for me since going on the court has been swearing in federal officials. I think I've heard more oaths than a bartender announcing its closing time. I have sworn in Elizabeth Dole, Margaret Heckler twice, other cabinet members, ambassadors, appointees, judges, and so on. You should also know, I think, that the Supreme Court is the backbone of the paper industry in America. We don't talk about our differences, we write about them. The amount of reading required just to vote intelligently on the petitions for certiorari and the appeals is staggering. The petition screening function of the court is a significant aspect of our work as justices. These applications come to us throughout the year. Since I have been on the court, we have received well over 4,000 applications a year. We are able to accept for plenary review no more than about 150 or so a term. We decide summarily up to another 150 or so without the benefit of oral argument and full briefing. As you know, the court has no hard and fast rules to guide or restrict it in our decisions on which cases to accept. Of course, with appeals, our discretion is greatly restricted, but with petitions for certiorari, we have full discretion. We follow an unwritten policy that it takes the agreement of at least 4 of the 9 justices to accept a case for review by the court. We consider with each petition the importance of the issue, the extent to which it's likely to recur in various courts around the country, and the extent to which lower courts, in considering the issue, have reached conflicting holdings on it. My own evaluation of the applications is based on the primary role I feel the court has. As all of you know, our Constitution leaves in place the 50 separate state court systems. It also provides for a parallel federal court system to be established by Congress, which now has 13 federal circuits. All of these courts, state and federal, are empowered to decide issues of federal law. Only one court is empowered to definitively resolve the inevitable conflicts in the holdings of all these courts. That is the Supreme Court. Our role then, as I see it, is to try to develop a reasonably uniform and consistent body of federal law. Petitions for certiorari and cases posing a genuine conflict among lower courts on an important issue are much more likely to garner the required number of votes to grant the petition. Partially because I never thought I would end up where I am, I had no preconceived ideas about the job of being a justice. I was not admitted to practice before the Supreme Court. The first oral argument I saw in the court was one I saw as a member of that body. I guess that the same could be said for most justices, at least until recent years. I had no specific ideas about the mechanics of being a justice or what the real decision-making process on the court was like. One of the earliest and most rewarding experiences, and one which I didn't fully anticipate, was the warmth, the kindness, and the civility of my fellow justices. Every one of my 8 colleagues has been very thoughtful and considerate to me. I consider them all good friends, and I have the highest personal and professional respect for each of them. There have been times in the past with some previous courts when some members of the court did not get along well together, and some animosity persisted among some of the justices. Happily, that's not the situation with the present court. It is a particular pleasure to be able to serve in an atmosphere of respect and affection for one's colleagues. Our newest justice, Justice Scalia, is a very fine addition to the court, both intellectually and personally. The oral arguments heard at the court are usually quite good. I suspect the lawyers arguing cases at the court take pains to try to prepare well for them and to present them properly. I always enjoy looking at the lawyer's application for admission to the Supreme Court bar to find out the lawyer's age, birthplace, law school, and experience. I've been surprised by the rather extensive amount of questioning by our bench and by the informality of that exchange. There appears to be even livelier questioning with our newly constituted court. I think all the justices enjoy the oral arguments. I doubt that many cases are won or lost on the basis of oral arguments, but occasionally a position will be strengthened or weakened considerably as a result of the probing done at oral arguments. I've been pleased to see more and more women lawyers argue cases at the court. Last term, some 32 women lawyers, about 10%, took the podium to argue cases. My perception is they've done exceedingly well, for the most part. The 1 hour, which we normally allot for oral argument, is usually entirely adequate in my view. In fact, the lawyers in at least 10% of the cases use less than their allotted time. Each week in which we hear oral arguments, the justices also meet to discuss the cases argued that week. It's usually the first and last time we discuss those cases. One surprise to me was that the oral dialogue between the justices is less than I thought it would be. I had always assumed there would be lengthier debates in the conferences of the justices. As time goes on, I can appreciate more why that doesn't happen to the extent I thought it would. By the time we confer, each of us has read the briefs, the key legal precedents, and we've thought about the case in some depth. I always assign a law clerk to do additional research on every argued case and to identify any helpful law review articles or texts on the subject. We have heard the oral arguments, and we know as much about the case as we are likely to know unless we're asked to write the opinion for the court. So when we meet at conference, each justice then expresses his or her views on how the case should be resolved and why. If there's any uncertainty in the views expressed, the problems are generally resolved in the process of the circulation of written drafts of opinions. The opinion writing process at the court is one which affords each justice ample opportunity to suggest changes or different approaches in a circulating draft. Sometimes a simple addition, deletion, or rephrasing will be suggested by a justice. Occasionally, a circulation of a proposed dissenting or concurring opinion will cause the writer of the majority opinion to make major revisions in it. There's a considerable amount of redrafting of circulating opinions before agreement is reached in a number of the cases. The system appears to me, at least, to work reasonably well. I'm sometimes asked about the role of concurring and dissenting opinions in the work of the court. It is a practice which has grown through the years. As you undoubtedly know, relatively few of the court's opinions are unanimous. Indeed, nowadays, one can say of the dissenting opinion, as Mark Twain once said of the Legion of Honor, that few escape it. I don't find the numerous dissents especially surprising among a group of 9 strong-willed people of diverse background and experience, nor do I find the frequency of dissents particularly worrisome. What is quite remarkable, in my view, is that each and every petition for certiorari and each jurisdictional statement, whether produced by a sophisticated lawyer or written by the hand of a prisoner in jail or an impoverished private citizen, is reviewed with care by all 9 justices. Is it not also encouraging to know that each and every written opinion of the court is read with utmost care and attention by every other justice, and a number of very bright law clerks as well, with an eye towards refinement or improvement? I think it's reason to have some faith in our system. On the other hand, if some of you sometimes think that our process at the Supreme Court results in too many reversals, you might take solace in the story of that crusty Southern trial court judge whose seat-of-the-pants opinions were always being reversed on some fine point of law. One day, a newspaper reporter called the judge to let him know that at last one of his opinions had been affirmed and upheld on appeal. When the reporter asked the judge for a comment, the judge thought for a moment and then said, "Well, I still think I was right." People often think of the Supreme Court as a remote and a distant Washington institution. It's easy enough to view the court as just another large federal building, distant and out of touch with the people of the country. But if you look at the history of the people who make up the court, quite a different picture emerges. The court is part of the national government, and it, like the other branches, is government of the people. Those who are privileged to serve on the court bring a wealth of experience from state or federal government, from academia, and from private practice. Justices are answerable not to the electorate, but to precedent, to statute, and the Constitution. Nonetheless, the court is built by the people who are called to serve as justices. It is their vision, their integrity, their reverence for the law, and their experiences and background that give life and texture to all the court does. Justices are drawn from all over the country. They're a diverse group. This, in my view, is reason to be optimistic about the court. Diversity is the strength of Cleveland, of Arizona, of Washington, D.C., and of America itself. In my 5+ years on the court, I have learned at least one lesson vividly. A justice is constantly called upon to try to draw some harmony from that diversity and even to reconcile the irreconcilable. I'm sure we don't always succeed in striking precisely the right balance among the competing ideals of law and individual freedom and justice. But you can be confident that we never stop trying. And if you're not happy with every opinion that comes down from the court, I can only say you are probably not alone. It's safe to say that at least one lawyer disagrees with almost every opinion we hand down. We don't take a case without two sides to it, and one side must always lose. Indeed, I've known a few judges whose natural temperament led them to try to decide cases against the lawyers on both sides. But generally speaking, those efforts have not been crowned with success. I think our new Chief Justice, William Rehnquist, explained the court's role and dilemma very well recently at Justice Stewart's memorial service. This is what he said. Many of the questions which perplex the court will not be resolved in our time. They embody the issues on which judges of different philosophies can and do often disagree. The judicial quest is not to finally put at rest the claims of government against the claims of the individual, the need for order against the desire for liberty. That is too much to ask of any judges who are, after all, human. The quest, rather, is to draw the boundaries in each succeeding case, knowing that our efforts are apt to be as transient as those of our predecessors, and very likely those of our successors. Thank you.
Thank you, Justice O'Connor. Today at the City Club of Cleveland, we've been listening to Associate Supreme Court Justice Sandra Day O'Connor speaking on the workings of the Supreme Court. In a minute, we'll turn to our usual question period. But first, as always, some announcements. As this is a members-only forum, my comments relative to membership are obviously addressed to our radio and TV audience today. No matter where you live in the United States or Canada, if you enjoy these weekly forums and believe in the importance of free speech, you can be a part of the City Club's great tradition. As a national member of the City Club, you'll receive the club's weekly newsletter with information about upcoming speakers, and you'll have the satisfaction of being part of America's oldest, uninterrupted forum for free speech and the lively exchange of ideas. For information about how you can become a national member of the City Club, write to us at the City Club, 850 Euclid Avenue, Cleveland, Ohio, 44114, or call us at 216-621-0082. And now for our question period. And before we start taking questions, I must caution you, obviously the Justice cannot and will not answer questions on any pending cases or on matters that are likely to come before her in her role as an Associate Justice of the Court. We have two microphones, one in the front of the room with Alan Davis, one at the rear with Bob Conrad. Please keep your questions as questioned. And now the first question, please.
All right. Justice, if it be permitted, I'd appreciate your comments on these two questions. When does life begin and when does life end?
I don't think I will try to answer those life great questions today. They do arise, you know, in connection with some of the arguments made to us on the abortion issue. And the court, not infrequently in recent years, has had to address that issue in one form or another. With your indulgence, I think I won't try to respond to those today.
Justice, there have been Supreme Court cases that have dealt with the issue of whether an opinion is the supreme law of the land or is binding only on the litigants in the particular case. Could you comment on that for us and perhaps give us a lesson in history and your own observations on what the future might be as far as what the effect is of a Supreme Court opinion on those of us who are not involved in the particular case?
Opinions of the Supreme Court, like those of any lower court having jurisdiction of the case, are of course immediately binding on the parties to the case. Not infrequently, a lawsuit will be brought in the form of a class action representing named and in some instances unnamed plaintiffs as part of a class or group. And of course, the judgment of the court becomes binding on all members of the class as well as any other named party. Beyond that, when the Supreme Court issues an interpretation that is definitive, for example, about the meaning of a particular federal statute or a particular action of some federal regulatory agency, by way of example, it is expected that those decisions will govern when the same identical issue arises in any other court in the land, state or federal. Of course, the court has no enforcement powers of its own, as you know. We don't have an army of police or magistrates out there to run around the country and enforce our rulings. As you all probably remember, when the court in the 50s handed down that famous decision in Brown versus Board of Education, holding that the Constitution is violated when public schools are segregated on the basis of race, there was some difficulty for a time in seeing to it that all schools around the country followed that concept. And in a rather dramatic incident, on one occasion, President Eisenhower actually called out federal troops to try to enforce the effect of the court's ruling in a particular instance. That was an example of the executive branch choosing to take particular action to put into effect the court's ruling in a particular issue. It seems to me that by and large, if we look at the history of the court and the history of the country, there has been tremendously wide acceptance nationwide of rulings of the court on most issues. One example comes to mind. You remember the case of Gideon against Wainwright. That was a case in which a prisoner in a state prison in Florida filed a handwritten petition with the court, written on prison stationery, asking the court, the Supreme Court of the United States, to hear his case. He argued that he had been tried and convicted of a crime in state court without the benefit of an attorney and had been sentenced to a term in prison. The Supreme Court decided to accept that petition, appointed counsel for him, the case was argued, and the court decided that the Constitution did indeed require states to furnish lawyers for indigent people accused of crime, at least felonies. And the response nationwide to that holding of the court, which was novel at the time, was dramatic and immediate. The state of Florida, within a year, had, that's the very state in which Gideon was tried and convicted. Florida responded in all of its counties by immediately developing a public defender's office. And states nationwide seemed to respond similarly and willingly to that holding of the court. And I think that's one of many examples of response by the nation to court rulings.
Madam Justice, the last two appointments to the Supreme Court have been of what we consider a conservative nature. Do you believe that if the next appointment would come soon, that it will finally change the direction of the court from a more liberal to a more conservative, and how do you feel about it?
Well, I have no idea. In the first place, I'm not aware that there's going to be a vacancy soon. If there is, my colleagues have neglected to tell me. And as we all know, it's difficult for presidents to decide whom to appoint when a vacancy does occur. And if that situation arises, I'm sure that I, like you, will be wondering who the next appointee will be.
Justice, it's recently been reported that the White House has screened potential federal judicial candidates not on the basis of their judicial competence, but more on the basis of their political persuasion and on the basis of how they might rule on certain constitutional issues in the future. Would you comment on that, please?
I have no knowledge other than my own experience about any such questioning. And I have met some of the fairly recent appointees to the federal bench and have been impressed with a number of those appointments. I know particularly some in Arizona, people with whom I've worked, who've been appointed within the Ninth Circuit, and they've been superb appointments. So I suppose it depends on individual cases how we would evaluate a particular appointee. But those I've known, in any event, who've been appointed recently have been very excellent.
Madam Speaker, I rise as one of the few non-lawyers in today's audience, and I'm not sure if you can answer the question, but I've been listening to the comments made by Attorney General Edwin Meese, and I must say he sounds less like an Attorney General and more like a field marshal. What do you think of his comments about the Miranda decision? And he also said he feels that perhaps the Supreme Court is not the final judge of law in this land, which seems to put Marbury versus Madison out of touch. Can you comment on either one of those two things?
Well, I think I've probably already described how I think the nation historically has responded to Supreme Court holdings and have explained, at least to a degree, how I think they have been followed and the parties that are bound. It might be useful for me to also explain how an attorney general or an attorney general and a president have an opportunity to bring their views on specific issues before the court. We do have a mechanism for that, and it works in every administration, this one and preceding administrations. The President appoints a Solicitor General of the United States. I believe that that selection is usually made on the recommendation of the Attorney General, in whose office the Solicitor General serves. The federal government, in its dealings with the Supreme Court, is represented then by the office of the Solicitor General. Traditionally, the Solicitor Generals in this country have been very well qualified lawyers who've done a superb job, and they are highly respected. Now, an administration, a president, and an attorney general have an opportunity to bring to the Supreme Court's attention, by way of the filing of a petition for certiorari or an appeal, in specific cases decided in lower courts in which the federal government is a party, issues which that administration thinks have been decided erroneously by the courts below. And it is that mechanism, then, by which the Solicitor General brings cases to the court for its review to see whether the members of the court think that certiorari should be granted. And I'm sure that all courts, the current one and preceding ones, take seriously the petitions of the Solicitor General for review of particular cases. If we accept the case for review, then the Solicitor General, again speaking for the Attorney General and the President, have an opportunity to present, by way of the written briefs and their oral arguments, particular positions on that particular case which the court has accepted, and give the court their argument in favor of a decision of the case in a certain way or following certain principles. And in that fashion, through actual cases and controversies that have come up through the lower courts, an administration has an opportunity to raise specific issues and proposals with the Supreme Court. The process is working that way today, and it has worked that way in the past. Whether or not the court accepts a particular proposal for resolving an issue depends on the views of the justices deciding the cases at that time.
Justice O'Connor, you've described the process by which the justices are all reading all of the material that is being circulated. There's been a great deal spoken and written about the overwhelming nature of the multiplication of cases, the increased demands upon the justices, to the extent that there are now discussions of parallel systems of relief of one type or another to enable you to perform the function that is so important. Do you or other individual justices have thoughts in that regard that you feel free to discuss here?
Yes, I'll give you my view, and I won't try to give the views of my colleagues. The Supreme Court, of course, sits at the tip of the pyramid and receives applications for taking cases that are generated by all the Supreme Courts of the 50 states and by the federal courts of appeal in the 13 different circuits. With the growth and population of the United States and with our tradition for litigation in this country, the numbers have grown very large of these cases decided in the lower courts. Inevitably, then, the pressures increase on our court by way of numbers of applications for cases to be resolved. If you look back over a period of 25 or 50 years, you see a pretty steady increase in the number of these applications. The court is operating, in my view, at maximum capacity now by taking some 150 cases a year for plenary review. It's a tremendous amount of work with that number of cases for review and with the number of applications we must screen. We read all the time and work very hard to keep up with that. To the extent that we value having a court in this nation which can bring some uniformity and consistency to the growing body of federal law, then we have to face up to the fact that the nation will have to have some means for expanding our capacity to resolve these issues. I think that it would be appropriate if Congress would think about and consider empowering the Supreme Court to impanel some existing federal appellate court judges, for example, to whom we might refer some cases For example, cases which we otherwise would be unable to take and hear, simply to get those conflicts resolved. I trust that at some time in the future, Congress will take a serious look at such a suggestion.
Madam Justice, the Phi Alpha Delta Mech chapter at the Cleveland Marshall Law School sends its regards to you and wishes you well here in your stay in Cleveland. I wanted to ask you about selection of law clerks. Justice Frankfurter once said, when you want good groceries, you go to Magruder's in Washington. If you want good law clerks, you go to Harvard University. I was wondering what are your criteria when you select law clerks, and what are you looking for when you...
All right, good question. And easily answered, I might add. I look for the best qualified from Harvard and elsewhere. I currently have 4 law clerks, and oddly enough, I have a man and a woman from Stanford University Law School this year, and a man and a woman from Harvard Law School this year. In the past, I've had clerks from a wide variety of law schools across the country, and very wonderful clerks, too. We are so blessed at the Supreme Court because we receive applications from all around the country of the most brilliant and talented young lawyers that you could find, people who want the privilege of serving as a law clerk on our court. It's just a luxury of riches, really. And the hardest decision I make every year is not those impossible issues that come before the court, but it's the selection of law clerks from such an array of talent. I receive hundreds of applications each year from people who want to be my clerk, and the other justices likewise. We have different patterns and practices with regard to how we select them. I personally review the applications that come in, read the letters of recommendation, scan things that the applicants have written that they tell me about, and then try to set aside maybe 50 of the applications as being worthy of closer scrutiny, shall we say. And then I go over the 50 or so I've set aside with great care. And I often will ask my current law clerks to also look at those files, and maybe they'll see something that I don't in connection with a particular application. I try to limit my interviews of applicants to no more than about 10 people a year, and then select 4. And the ones I take are certainly incredibly well qualified. And they're such nice, talented young people. It gives you enormous faith in this country and in the youth of this country to see what a high-quality individual we get at the court. We work so closely with them during the year. They become like members of my own family. And it's heart-wrenching at the end of the year to bid them farewell. But I stay in touch in later years and watch with great interest their progress. It's one of the joys of the position.
The Supreme Court oral argument tapes were at one time made available to academic law libraries. They've been very useful materials. However, under the last Chief Justice, they became unavailable. Is there any chance that under the current Chief Justice there might be a reconsideration so they're once more available through the National Archives?
It is my understanding that indeed the court has agreed to furnish tapes to the National Archives. And I think that is being implemented now. I would have to check up on it, but it is my understanding that there was a gap of time in which tapes were not sent over, but I think they are being sent, and maybe past years have been caught up and sent over. That's my understanding.
Justice O'Connor, in your recital of the mechanics of the Supreme Court, it occurred to me to ask, is there a pecking order? That is, as a junior member, are you assigned different tasks than say, some of the older members or
Oh,
longer time?
yes, indeed. And I've just graduated. It's wonderful. Oh, dear. The junior member of the court, by tradition, does a couple of things, or at least three things. Let me start with the third first. The junior member always walks in last after the other justices. So wherever we go, whether it's walking out onto the bench or walking over to hear the President's State of the Union or whatever it might be, we walk in order of seniority, except for the Chief Justice, who, of course, goes first. Now, the junior justice also has to sit next to the door in our conference room. Our conferences are attended only by the justices. There is no staff person present at all. If messages have to be sent in or out to a member of the court during the conference, then the knock at the door is answered by the junior justice. Now, the third thing the junior justice is asked to do by tradition is to prepare the court's order list. Each conference we are voting on which cases to accept, which petitions for certiorari and appeals to take, and we are drafting orders in connection with a variety of motions and other applications to the court. And the junior justice has to prepare those orders and then meet with the staff of the clerk of the court to see to it that they are published and released on schedule as a result of the court's meetings. And I was very happy indeed, after 5 years, to hand that task over to Justice Scalia.
Justice O'Connor, if there is a constitutional dispute between the Congress and the President regarding separation of powers issue, is there any role for the Supreme Court to play if neither one of the disputing parties chooses to involve it?
No, of course, our Constitution limits our jurisdiction to only cases and controversies. That means there has to be a genuine dispute on an issue of federal law amongst parties with standing to raise the dispute. It has to come to us through the channels provided by law for us to receive and decide. And so if other branches of government have a dispute and do not take it to court, we don't hear it and would have no opportunity to do so.
Justice O'Connor, how is the opinion writing assigned among the justices of the court? And are there any areas in which you have been more inclined to write opinions than others?
If the Chief Justice is voting in the majority on a particular case, then the Chief Justice makes the writing assignment to some member of the court in the majority on that particular case. If the Chief Justice is voting with the minority of the court on a particular case, the assignment function goes to the most senior member of the court in the majority on that case, who then can make the assignment to someone in the majority. There really is no lobbying, if you will, among the justices to get a particular assignment. You take what you get, and you take what you're assigned. I think that's something that people don't often realize. We aren't out there writing for the court without an assignment to do so, and we haven't asked for that assignment. But when we express our opinion at a conference on a case, we have to be prepared to back that opinion up by a willingness to write it up if we're asked to do so. Anyone is free to write in dissent, however.
Justice O'Connor, this year, most of us, I believe, are celebrating the 200th anniversary of our Constitution. Although in the last few years, a number of people have been urging state legislatures to call for a constitutional convention. Would you share with us your observations on the vitality of that 200-year-old document today?
Well, speaking as one member of the court, having to deal with it day in and day out, it looks pretty vital to me. very much alive, very healthy, and very well used in the courts. It is absolutely remarkable to me that in any given oral argument session, we schedule about 24 cases over a 2-week interval each month. It is unbelievable to see the diversity of issues that come to the court during that 2-week period. In addition to issues of statutory interpretation of acts passed by Congress and review of federal administrative action, we have innumerable opportunities to decide issues of constitutional law. And they range from issues under any of the Bill of Rights to substantive provisions of the original Constitution. We are apt to see and have within the last argument session, I think, issues under the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Property Takings Clause, the Contract Clause. It is just astounding that this document, written so long ago, has served us as well as it has. It was written in broad general terms, which is no doubt why we have so many cases and so many options for decision. But also because of that, it seems that the Constitution has been an enduring and a remarkable, indeed an inspired document, very much alive, very healthy, and very much in use today.
Justice O'Connor, first I would like to welcome a fellow Stanford Law School graduate to the City Club. You've been asked about the liberal versus conservative court. I'd like to ask a bit of a related question. One of the issues that is frequently discussed in judicial decision-making is whether the court is an activist court. My understanding is that activist court is one who is accused of taking the prerogatives of the legislature. Now, as one of the few, or perhaps even the only former legislator currently serving on the court, I'd be interested in light of your experience as a legislator, whether you think this is an activist court.
Well, I think you'd have to answer that with reference to specific cases, and I'm sure that opinions would differ. Some might say that a particular decision was, quote, activist, unquote, while another was deferential, if you will, to legislative decision-making. We would have to look with some specificity. It seems to me that the court is constantly being asked to review and interpret statutes passed by Congress. Congress passes so many complicated laws. Let me just mention a couple in passing. ERISA, OSHA, the Environmental Protection Act, the Clean Water Act, Title VII, Title VI. Really, there are a great many massive pieces of legislation, not to mention the federal income tax code, which have to be decided at the court, questions of interpretation. Now, laws are like sausages. It's better if you don't know how they're made. By that, I refer to the fact that very often in the legislative process, a particular piece of legislation or a statute will often be the product of compromise. Amendments will be made to a bill as it goes through the hopper and it goes through committees and as it goes to the floor. Some of these amendments knowingly make the language more ambiguous. Some of them accidentally make the language more ambiguous. In either instance, it's up to the courts, ultimately, to have to try to make sense of a particular statute and to apply it with whatever the court determines to have been the actual intent of the legislative body that passed it. And sometimes that's very difficult. With Congress, you have a legislative history. You have committee reports to examine. And there is difference of opinion among judges as to the extent to which we should rely on those committee reports. Some say they are prepared by staff and don't represent the thinking of the legislators at all, so you should look at the plain language of the statute. But when the plain language of the statute is ambiguous, to what does one refer? Do we look only at the debate, the remarks on the floor of each House when the measure is passed, or do we examine the committee reports? I think the court has done a little of each of those things over time and looks at the language of the particular measure. We often do look at committee reports, and we of course, look at the remarks made, particularly by sponsoring members at time of passage. And in that manner, we try to divine the intent of the legislative body. It's not an easy task, and having been a legislator, I know how many gaps legislative bodies often leave in particular enactments to be filled in later by courts.
Thank you, Justice O'Connor. Today at the City Club, we have heard Associate Justice of the Supreme Court of the United States, Sandra Day O'Connor. The City Club Forum is adjourned.